Assalamu alaikum and hi Abid to Prof. Zainal and my fellow classmates and whoever else may be watching. We are from Group 1 and this is our video presentation on the analysis on the two issues pertaining to the transfer of cases under the Criminal Procedure Code and suggestions for effective solutions. The Criminal Procedural Code and certain other statutory provisions provide the ability of courts to transfer cases from one court to another. Accordingly, the transfer of cases can be made either by lateral transfer or vertical transfer. My rights to equal protection of the law is violated because the transfer of my case. I hear that, sister. And there are two aspects to be discussed in relation with the transfer of cases and the violation with Article 8 of the Federal Constitution. The first aspect is the possibility of the accused being exposed to harsher punishments. Section 177 of the Criminal Procedural Code states the ability for the magistrate court and public prosecutor to transfer cases. The concern that arises with this ability to transfer cases is actually when the trial court has jurisdiction to hear the criminal offences and pass a sentence that falls within its said jurisdiction. This has been contested in the case of Raja Petra, where it was stated that the transfer of cases from the magistrate court with the competent jurisdiction to try the offences of the session court with jurisdiction to pass heavier sentences is a serious violation of Article 8, Clause 1 of the Federal Constitution. Next, in relation to the violation of Article 8 of the Federal Constitution, transfer of cases, especially in relation to the transfer of cases to the High Court, have been contested as depriving the accused to the benefit of preliminary inquiry. Section 417 of the Criminal Procedural Code states the ability for the High Court to transfer cases, and Section 418 Clause 1 of the CPC states that the application of the public prosecutor to transfer cases made to the High Court need not be supported with an affidavit. The question arises is whether the transfer of case to the High Court would actually deprive the accused of the benefit of a preliminary inquiry. This concern has been contended in the case of Oh Keng Seng. In addition to the contention that the accused has lost the right of appeal by transferring the cases from a subordinate court to a high court, which the accused would otherwise have from the lower court to the high court. Hence, it can clearly be seen that the transfer of cases have been deemed to as violating the accused's rights for equality under Article 8, Clause 1 of the Federal Constitution. Because of this, is there no hope to restore the confidence in the criminal procedure in any?
I don't think so, Eleanor, because after we did the analyzing part, we do found several solutions to improve the justice regarding to the transfer of cases in relation to the first issue. So here we have like three recommendations, which is first, we want to instate judiciary engagement, and second, we can actively seek senior judges' wisdom. Fourth, the public prosecutor may provide a supporting document if they want to transfer a cases. Here, firstly, what do we mean by we want to instate judiciary engagement? Because the transfer of cases is still subject to the court discretionary power. As we learned, we know that the court or the judiciary is an organ that will observe the check and balance power between the legislative and the executive. So here, we want to highlighted that the transfer of cases is still subjected to the court approval, which means that the court will allow and reject such application as it deems fit. Although there discretionary power for the public prosecutor to transfer the cases, however, it's still subjected to the approval of the court. There's no such thing as absolute power for the public prosecutor to transfer the cases because it's still subjected to the approval from the court. And it can be seen in the illustration of the case of public prosecutor and versus Tengku Hitam, where the court held that the prosecution must satisfy itself whether the maximum punishment which such court can impose is adequate. So which means that the public prosecution, although they have a power to transfer the cases, but they must give a reasonable ground for the transfer of cases to be made. And it's still subjected to the approval of the court, whether the court approve or not. So that we must instill judiciary engagement to check and balance the power between the prosecution and the judiciary. Through the cases, we believe that the accused is always inclined for their cases to be transferred from the lower to the higher court, because they believe that if they transfer their cases to lower to higher court, they will receive a harsher punishment. But the court highlighted and emphasized that in the case of Raja Petra bin Raja Kamarudin versus public prosecutor, that the court held that the transferring cases from the session court would not result in a harsher sentence, which means that the transfer of cases usually not for a harsher sentence, but they require more knowledgeable judges and a more senior judges to conduct or to give their opinion regarding the the nature of the criminal matter, because some of the criminal matter do require senior and knowledgeable judges to have their input before the sentence being passed. So there's no such thing as harsher sentence when the case being transferred from the lower to the higher court. So we recommend that the public prosecutors seek wisdom of the senior judges, not because they want to impose a harsher sentence. So, okay, last but not least, we would like to recommend that the affidavit requirement that being imposed to the accused if they want to transfer their cases is being imposed also to the public prosecutor in order for them to transfer the cases, because we believe by doing so it can maintain the confidence between the prosecution and the judiciary. And we believe that if the public prosecutor also abide the provision stated in the CPC, whereby that the notice must be given at least 24 hours to the court, it can avoid the conflict of interest between the accused. So, meaning to say that if the public prosecutor at least consider our three solution pertaining to the first issue, I think the public prosecutor can ensure that the right to equality under Article 8 of the Federal Constitution can be preserved. So, as illustrated in the case of PP versus Okenseng, the court said that the position of the accused is not altered in any way to his determined by having his cases transferred. So, meaning to say that if the public prosecutor actually consider our solution, I think the right to equality under Article 8 can be preserved, and the accused also need not to be afraid of his case being transferred from the lower to the higher court. I think that's all for me. Thank you. Excuse me, this is a right to violation. I'm the Chief Justice, and I don't take the corruption money.
Hi, Listen here. I understand your situations. Normally, the accused like you is the one who transfer your case before the trial with an affidavit under Section 417 and the 418 of CPC. And there are two common grounds. Under subsection E is expedient for the ends of justice. For example, in Abdul Aziz case, the respondent raised his position as being the member of the parliament and claimed their high-profile witness. As for this, there are two contradicting views. It's allowed in the Dato' Harun's case, but limited to the public figures who possess the greater attraction to the public interest considerations. And another views reject it. In Yong's case, public interest does not refer to the former prime minister position itself, but rather to the demands of the justice, seriousness of the charges, and the delay in commencing the case. Hence, let's look at the provision itself. It's wide and embrace grounds outside the clause for securing justice and a fair trial. For Riza Sari's case, public interest considerations would justify the trial, but there's a question. From the principle of equality, whether politicians can legitimately be treated the same as other accused. Another ground is the subsection B, the question of law of unusual difficulty. For example, in Abdul Aziz case, they claim they have complicated facts. Citing AG versus Kochunpua, it was held that the issue concerning banking and the shipping practice did not beyond the competency of the court. In provisions, unusual means a unique or out of the usual or ordinary or not by any court before. It must be extraordinary. Actually, Dato' Chi's case commented this provision is obsolescence. In Lin versus public prosecutor, it said to cater for the past era where judicial officers were either not legally qualified or were inexperienced. For now, it was extremely difficult to say so, having regard to their legal qualifications, considerable experience, and professional competence. Hence, the high-profile case like Abdul Aziz and Riza Saris has also failed in relying on this ground. Jun, do you think high-profile case guaranteed to win in transferring the case?
Yeah. Your question is interesting, and I will answer your questions with my 4 points here. First, it's important to emphasize on independence of judiciary power. It cannot be said like the accused is an ex-prime minister, so his application to transfer can be automatically allowed. That's unfair. The judiciary power cannot be affected by other influences so as to uphold the rule of law and preserve natural justice. That is to say, even if both parties consented to the transfer, like what's happening in Yong Chu Keung and Abdul Aziz case, the court should reserve his discretion to dismiss the application. Next is exercise of judiciary discretion within the ambit of Section 417 of CPC. It means that Section 417 is the standard. Every accused, regardless of their status, like what has been stated in Wong Hong Toi's case, they are bound by the same standards. So this could resolve the concern of inequality between political personalities and general public in the transfer of cases. The third solution is avoid using the accused status as the sole ground because aside from the identity of the accused, the court will also consider the background of the case and the substance of the charges in exercising its discretion to transfer a case. If the applicant wants to rely on the ground of expedience for the end of justice, the purpose must be to avoid delay of the trial and the case involves serious charges affecting the public interest. The Dato Sri Najib case is a good instance where the application of transfer was allowed because the delay of the trial can be avoided by having 7 charges to be heard together. The charges against the accused were so serious and generated local and international public interest. And lastly, the accused will not suffer any prejudice or injustice from the transfer. In some high-profile cases, the applicant will also say that a transfer of case is required because question of law of unusual difficulties is likely to arise. But for this ground, the threshold is extremely difficult to be fulfilled in the present day. Therefore, we humbly suggest that this ground would hardly justify a transfer of high-profile case unless the applicant is able to show that the issue involved is unusually complicated after considering all factors. In conclusion, we found out that most of the cases could be resolved by referring to the CPC. What's important is that the court has to exercise the power to transfer with circumspection and act fairly in balancing the right of the party in choosing their own forum, at the same time exercise proper administration of justice. That's all from us. Thank you.